Welcome back to our YouTube channel, Global Immigration. Today, we will talk about how we can convert our visit visa into permanent residency. It will be an interesting discussion. Please watch video till the end. I'm talking about dependent parents or dependent relatives that come to the UK as visitors, and due to a change of circumstances, due to problems, due to the fact that they can't go and live by themselves in their home countries, they are forced to make applications to stay in the UK. If you look at the rules do not allow you to switch from a visit visa onto any other category. If you're here as a visitor, you're supposed to go back to your country and make an appropriate application if you wish to come and live in the UK. What I'm talking about is a situation where you are a British national or you are a person with indefinite leave, or you have refugee status, or you could be a student, or you could be a skilled worker, or anybody. The point is, the situation that you find yourself into is that your parent, or a surviving parent, or both, if they are at that old age, or another dependent relative who is financially dependent, or otherwise dependent on you, comes to visit you in the UK, and there is a change of circumstances due to which they cannot go back and wish to stay here with you. Now, just for simplicity, let's take the example of a case that I've just recently done. Yesterday, we got the decision from the court. The appeal has been allowed. Now, what happened in this matter? And of course, this is a massive family that I'm talking about. They've got all their family members in the UK. The mother was the only person who was left alone, and she came over and joined the rest of the family as a visitor. When she came here, they saw the condition. They saw how she was. Sure, she was not doing very well as far as her health was concerned, so they were concerned and they talked to her about it. They looked at all the circumstances, her medication, what problems she was having, and they found out that she was extremely lonely, that she had a multitude of medical problems. She was obviously a widow. That's why we're talking about her being alone, and she had no one else to take care of her in her home country. Now, the proper application to do for her would have been an adult dependent relative application from the home country, which would mean that they had to make the application, pay the fees, provide all the evidence to show why she is unable to look after herself on a day-to-day basis, and that she requires long-term personal care, and that there is nobody in her home country to be able to do that for her. And because this difficulty that she's having is because of her age, illness, or a disability, she cannot be left on her own. Now, what we are saying then is that she is the person who needs to be looked after, and the family members in the UK are the only ones who are able to do so. Now, instead of making the application, she came to the UK as a visitor because she had a visitor visa. She'd been coming and going for a number of years. When she comes the last time, the family look at her, they are convinced that she is in no state to live by herself anymore and decide to do a leave to remain application for her to stay in the UK. This was before my team stepped into this matter. They made the application was refused as we expect them to be refused. So, we did another application, and I told the clients that because you've had a bad immigration history, you've already had a decision from the immigration judge, it may be refused. So, be prepared for that. And that is exactly what happened. The application was refused, and we were granted another right of appeal for which. So when we went into the appeal hearing, I think in January, if I'm not wrong, when we went for the appeal hearing, the starting point for the judge was the previous determination of the judge, which had completely destroyed their case and said, well, you were doing this on purpose, you knew what the rules were. You just wanted to circumvent the immigration rules, that's why you tried to switch her status from visitor visa to that of a dependent, and we are not having any of it. So the judge was quite upset about how the case had been presented. This was in the previous appeal. When we went into appeal, I was the one representing. in court. So what my argument was that previously whatever evidence had been submitted or how they had presented themselves was not very good, and that's why they had not been able to convince the judge about what the situation was. Now, we went in, we had the proper evidence, we had proper witness statements. I was arguing the case in court on their behalf, and my submissions were probably about 45 minutes to an hour, and when we came out, the family were of course very anxious about what's going to happen, but we were hopeful that something good would happen, and yesterday the decision arrives and the determination is in our favor. So, this lady is now going to be allowed to stay in the UK with her family members on the basis, not that she has met the rules on other dependent relative applications, but on the basis that there are exceptional circumstances, there are compassionate grounds on which she should be allowed to stay here. Case-to-case dependency, case-to-case facts that need to be looked at, and what they accept or what they reject will determine what happens later on. So, in this matter, she has now won the appeal. We are now waiting for the Home Office to issue her status documents. Once they have been issued, she'll be granted 2.5 years leave on a 10-year route to settlement, which means that she can stay here every 2.5 years. She'll be applied for an extension. She can travel. Well, she's not going to be working at her age and with her conditions, but she can travel and she can stay with her family. Now, this is the scenario that can be applied to brothers and sisters and cousins and uncles and aunts, anybody, because this is not within the rules. This is outside immigration rules. This is one of those examples where if you have a certain situation that has developed and you cannot deal with that situation under the immigration rules, you can